and we are going to open our program. I'm Alex Stoyev, the legal analyst of Danish Demining Group. Once again, we are pleased to welcome you here at this roundtable. It is supported by the European Union, as you can see in the logo. Also, we have some donors, such as USAID and the Embassy of the United States in Ukraine present here. Also, we have Donetsk and Luhansk Oblast administrations here, and also local self-governments from a couple of communities in those regions and other participants. Thank you for finding time, and for the welcoming word, I would like to give the floor to the director of the Danish Council. Brio, the floor is yours.
Thank you, Oleg. Dear representatives of the authorities and the government of Ukraine, dear donors, dear partners, dear colleagues and dear friends, I'm very happy to welcome you today to this roundtable organized by the Danish Refugee Council and the Danish Demining Group in Ukraine. And we are honored by your presence and participation to discuss with us the following topic: Mine Action Law of Ukraine, are we ready? As all of you know, the Mine Action Law of Ukraine was amended at the end of last year. And this was an important step in Ukraine's commitment to the national mine action response and its international obligations. DRC-DDG, together with other partners from the mine action community in Ukraine, contributed to shaping some of the key messages and recommendations to bring the provisions of the Mine Action Law in line with recognized standards and good practices. Since the amendment of the law, however, the focus of the international mine action community has been almost exclusively on the central mine action institutions, the National Mine Action Authority and National Mine Action Centers, which are crucial foundations of the mine action architecture in Ukraine. But the Mine Action Law also delegates important duties and responsibilities to another set of key stakeholders in this process, the local self-governments. And I hope that this roundtable will help you understand better these responsibilities and duties that fall under the authority of the local self-governments. In 2021, DRC-DDG executed a rapid needs assessment with 12 local self-governments, and the findings of these assessments led to the question that is raised today: are we ready? According to these findings, 90% of the local self-governments assessed were indeed aware of the Mine Action Law and its amendment. However, much fewer were aware that the amendment to the Mine Action Law will also directly relate to their duties and responsibilities in the protection of their residents. None of these local self-governments has assigned a budget to any mine action activities in the 2021 fiscal year, but almost half of them are planning to appoint a relevant mine action personnel as part of their administrations. Another positive finding is that 12 local self-governments assessed were eager to receive mine action trainings. Capitalizing on years of institutional development in Ukraine and using the opportunities offered by the decentralization process, DRC-DDG has been also increasing its support to the capacity building of local self-governments across many areas, such as legal support and economic recovery, and will continue its efforts with mine action initiatives. Today's roundtable is just the beginning of this effort and only the first of such events in the future. I hope it will provide a concise overview of what mine action is and the mine action stakes in Ukraine, as well as help you understand the links between the Mine Action Law and the local self-governments. This roundtable was made possible with the support of the European Union, as my colleague Oleg already mentioned, and I would like to thank its representatives for their presence and participation today. I wish you fruitful and productive discussions. Thank you very much.
Дякуємо, Бріо.
Thank you, Brio. So we are going to proceed with our today's agenda. Nick Wolk will make a 20-minute presentation on what exactly humanitarian mine action is. After that, we will have a section of duties and responsibilities of local self-governments according to the mine action law of Ukraine, after which we are going to have a 20 minutes Q&A session. Also, I would like to add that our presentation is being recorded, so you will be able to watch it in the current format in the Ukrainian language, but also in the English language as well. And you will not even have to write to us for this, because we will send the links to all the members represented today. I hope everyone could hear Bria's a welcoming word, and I hope that everyone can hear the interpretation so that all of us can be on the same page. And now, without further ado, I would like to invite Nick to open our next section with the presentation of Humanitarian Mine Action.
Thank you very much to Oleg and to Briu. I hope everybody hears me. Thank you very much to everybody who joined in the roundtable. Here at DRC-DDG, we think this is a very important topic. It opens up a lot of unknown topics, and this first roundtable is essentially organized in a way of raising the awareness of humanitarian mine action, broadly speaking, and that's the portion that I'll present right now. And of course, then also to humanitarian mine action and mine action that relates directly to Ukrainian context. You can move onwards with the slide. Looking at what I'll cover today right now, it's the 5 pillars of humanitarian mine action, as we call them. We'll look at some of the international frameworks and obligations. We'll go through these relatively quickly, essentially, but it is important to position the Ukrainian context and in a much more broader and global movement against mines and other explosive ordinances. And then finally, we'll look at the architecture of mine action here in Ukraine, following the amended mine action law. We'll look at how these sort of relates to one another and to participants of today. You can move onwards, thank you. So if we look at the so-called 5 pillars of humanitarian mine action, the first and foremost, and perhaps the most recognized one, is called humanitarian demining. In this pillar, there are different methodologies that humanitarian mine action operators use to remove explosive ordinances of all types. That includes non-technical survey, which is a way for us to delineate and find contamination without having any kind of technical approach to it. Then it moves on to technical survey, manual mine clearance, and battle area clearance, where all essentially to a certain extent use already a technical intervention to remove explosive ordinances. The next pillar is so-called explosive ordinance risk education. It used to be known under mine risk education as well, but it was revised last year in the International Mine Action Standards to be named EORE, so Explosive Ordnance Risk Education. It is a way of raising the awareness about the safety and life around explosive ordnance among the communities that live in EO-affected areas. The third pillar is victim assistance. It's a way of support to those who have been affected by either an accident involving an explosive ordinance or relatives of those who have been affected by accidents with explosive ordinances. The fourth pillar is advocacy. It is one of the things that you are today participating in, is raising the awareness about the effects of landmines and explosive ordinances, and a general awareness raising to not use them. And then the final pillar is so-called stockpile destruction. It's when a lot of different explosive ordinances are put together and destroyed. I have in Ukraine, international organizations can work in the first four pillars, while stockpile destruction is exclusively in the hands of the national response. There is a fifth, although not a proper pillar in itself, but it is something that happens in every country which is affected by mines and explosive ordinances, and it's happening here in Ukraine as well. It's the capacity building of national institutions that are in one way or another related to the response, the humanitarian mine action response. It is all the way up from the central institutions, as you will see later on in the architecture of mine action in Ukraine, and all the way down to local self-governments, which is why today we have this roundtable as well. DRC-DDG here in Ukraine covers all first four proper pillars: humanitarian demining, explosive ordnance risk education, victim assistance, and advocacy, as well as thus extensive capacity building specifically of the state emergency services. You can go forward with the slide now. Just to give you a little bit of a context and the time frame in which we find ourselves and what happened before in terms of international conventions. You can see that the first notice of the effects of landmines and explosive ordnance began in 1980s, when the UN Convention on Certain Conventional Weapons was concluded in Geneva. In 1988, so 8 years later, the UN makes the first appeal for humanitarian response to the problems of landmines. In 1997, then, the Anti-Personnel Mine Ban Convention enters into force, and the international campaign to ban landmines starts in 1999, producing the yearly reports on the global problems of landmines, bringing a lot more attention to this issue. You can see here in 2005, Ukraine ratifies the Anti-Personnel Mine Ban Convention, which is signed in 1999. And 5 years later, the Convention on Cluster Munitions also comes into force. There is also a number of international laws, such as the Disarmament Law and the International Humanitarian Law, also known as the Law of War, that govern the standards pertaining to mines and cluster munitions, to explosive ordnance generally, and ammunition stockpiles. We will look at a few of these conventions, like I said, very briefly, just as a understanding, but you can move forward in that. So here we start at the very beginning, at the Convention on Certain Conventional Weapons, the CCW. It's a framework treaty. It's applicable to situations of armed conflict, which contain generic provisions and protocols relating to specific weapons and their use. These protocols are Protocol 1, the Protocol 2, specifically on landmines, booby traps, and other devices, then Protocol 3 and 4 and 5. This convention was built on the customary rules that regulate the conduct of hostilities. They include the rules of distinction, proportionality, precautions in attacks, and the prohibition of weapons that are of nature to inflict gratuitous injury and suffering of combatants. You can move forward. The Anti-Personnel Mine Ban Convention prohibits the development and production, use, and transfer and stockpiling of anti-personnel mines. It requires the destruction of stockpiled anti-personnel mines within 4 years to all those who have ratified it. It requires the clearance of anti-personnel mines within 10 years and calls for the support for the assistance to victims. Okay, you can go forward. Then we go into the Convention on Cluster Munitions, the CCM. It prohibits the development, the production, the use, the transfer, and stockpiling of cluster munition. You can see what a cluster munition is on your picture on the left and how big it is. It requires also the destruction of stockpiled cluster munitions within 8 years. Then a clearance of cluster munition remnants. So any unexploded submunitions or abandoned cluster munitions, which is an example of that on the left, within 10 years. It also requires age and gender sensitive assistance to victims, especially for those injured by explosive submunitions and their families and affected communities in general. Okay, you can move onwards. State party meetings. All state party meetings are invited by the Secretary General of the United Nations to the annual meetings of the state parties, the MSP. All those who have signed any of these conventions, states that are not party, and then also the United Nations, other relevant international organizations, regional organizations, the ICRC, the International Committee of the Red Cross, and the International Federation of the Red Cross and Red Crescent Societies, as well as relevant non-governmental organizations are sometimes invited to attend this MSP. The MSP is usually hosted by the country assuming the presidency of that MSP. Okay, you can go forward. So let's look at where Ukraine's process in all of this is. So as we said before, Ukraine signed the Mine Ban Treaty on February 1999 and then ratified it in 2005. The convention entered into force a year later in 2006. On last year, Ukraine submitted a second request to extend its mine clearance deadline, and in August of the same year submitted some additional information to its request. The request was then granted at the 18th meeting of the state parties, and a new deadline was set for 2023. This essentially shows the extent of mine contamination in Ukraine and the amount of work required and the slow process that this work requires as well. To this date, Ukraine has not yet signed or ratified the Convention on Cluster Munitions, however. You can go forward. Like our country director has said at the very beginning, the amendment to the Mine Action Law of Ukraine was signed in December 2020, which did indeed signal an important achievement in the national mine action response. However, there are still certain important gaps in the law itself. The national budget is required for mine action activities. Their additional bylaws are also required to provide comprehensive and holistic victim assistance. A national mine action strategy, especially if aligned with the Protocol 5 of the Mine Ban Treaty, will further aid fundraising for mine action activities. And then finally, national mine action standards remain behind the international mine action standards, particularly and most pressingly on mine action data collection. You can move on. Thank you very much. And this is how the architecture of the mine action in Ukraine looks after the amended mine action law. At the very top, we have Parliament, which is the legislation and policy making body. Below it is the cabinet, which is provides the framework regulations. Underneath that is the so-called National Mine Action Authority. Currently, it's chaired by the Ministry of Defense, and it provides technical policy making. Left of it is the National Mine Action Authority Secretariat, which gives assistance and coordination to the two centers below. One of them is the Mine Action Center, which is also run by the Ministry of Defense. Pardon me, and the Humanitarian Demining Center, which is under the Ministry of Interior. And then underneath that, you can see it's the mine action operators and the local self-government. Mine action operators in Ukraine constitute DRC-DDG, clearly, the Halo Trust, the FSD, so the Swiss Foundation for Mine Action, certain local mine action operators as well, and so on and so forth, and local self-governments now with the decentralization process have become stakeholders in this architecture. And I believe this concludes my portion, and I will hand it now to Oleg to continue with the Mine Action Law of Ukraine more specifically. Thank you very much.
Дякуємо тобі, Нік. Спасибі за презентацію.
Thank you, Nick, for your presentation. I will remind you that we will have a chance to ask Nick questions after I finish my section and we proceed with the general discussion section. So right now, let us proceed with the issue of opportunities and obligations of the self-governments in the demining activities. So this situation was quite interesting because until 2014 it was quite complicated. We did not have any single legal document that would regulate this issue. There was no single governmental institution that would be contacted for explanations, and the involvement of local self-governments was not systematic. So, for instance, if at the territory governed by the local self-government, if there were victims, of course, it's impossible to get ready and to plan such a situation. So it's necessary to provide assistance as soon as possible in such a situation. And the problems were different each time. Each time they required some creativity from the self-governance. So this was an additional pressure on them. And this is why we are looking deeper into that right now. And we will be looking into the collaboration with National Mine Action Authority, which will be approved in the nearest time, and also the mine action centers, which are basically the governmental institutions on mine action. And also one more area is cooperation with operators such as Danish Demining Group. And also we will have a section on the assistance to victims, and we will also discuss the obligations of the self-governments, and also we will discuss the markings of the dangerous territories. So, as I have mentioned, this is a specific area. We will need some context to understand this, and for this, we will need to discuss the rights and obligations in the mine action. So before the law on mine action, everything was unclear. There was no single legal document that would define it. The constitution, we needed to look into the rules of the activity of the local self-governments, and the decentralization reform itself, it consisted on a big number of different legal documents. So even for us lawyers, it was quite difficult to understand about the obligations and the remit of the local self-governments. We hoped that with this law, the situation will become slightly clearer, but not really. So before that, there was some dualism in the legal sense, because on the one hand, there was a law which
В дійсності ж не було органу, який би проводив сертифікацію таких операторів. Закон говорив, органи місцевого самоврядування можуть контактувати із спеціальними органами у сфері протимінної діяльності для отримання якихось інструкцій, директив.
There was a need to follow some instructions, some directives, and in reality, something like this did not exist. And this complicated the thing even more. Since September 2020, we got something new. We got some amendments to the mine action law, and the intention was to remove the dualism, the mismatch between the legal reality and the actual reality. So after that, the Cabinet of Ministers and also the Ministry of Defense, the Ministry of the Internal, hopefully also the Ministry of Health will soon join them. They are accepting some they're developing some sub-laws to make this law actually work. So we have a number of sub-laws on mine action, and actually this is a very complicated area, because as I have mentioned before, these sub-laws, they do not describe direct responsibility of the local self-governments. Quite often, they impose some obligations on the local self-governments. And also at this level of sub-laws, there were some specific obligations. There were some obligations within specific orders by the Ministry of Defense, and there were lots of issues involving cooperation between the Ministry of Defense and Ministry of the Internal. All of those things are quite complicated and quite difficult even for a lawyer to understand. However, they are still in practice. So I will be describing this in more detail. This implies the social support, the clearance of the land, the marking, etc. And one more field here is the general legal documents and responsibilities of the self-governments. Within the decentralization reform, some obligations were imposed on the local self-governments, some responsibility for social security, for health, for ensuring the right to education. And as far as we can understand, Mine Action includes all of those components: social protection of victims, marking of the land, rehabilitation, social security payments. So when we discuss the obligations of the local self-governments, it does not, the topic does not limit itself to the Mine Action, but there is a list of legislation that you have to fulfill as local self-governments. And even if something is not directly included in the Mine Action law, it's not the reason for the local self-governments not to follow those requirements. That's because you already have this responsibility imposed on you as a part of the decentralization reform, and there is already some existing legal practice of application of that legislation. So right now we will transition to the law on mine action, but please keep in mind that it's not about just one law. It's about the existing practice of using the general Ukrainian legislation framework, and it only became slightly different with these amendments of the Ukrainian mine action law. So in order to understand this better, in order to understand the rights and obligations of the local self-governments, we need to understand what is happening at the level of the cabinet. Over the next month, the cabinet has to approve the sub-laws about the national mine action authority. Then we expect it to be created within 2 or 3 months. Then also the parliament, together with the cabinet, they have to create a number of documents, such as the national plan, the national strategy, and also the program for mine action, and also the yearly plans. This is important because the local self-governments are going to take part in the development of those programmatic documents, and the National Mine Action Authority will be contacting you with questions about your needs and problems in the field of mine action. They will be asking whether you have any problems with contaminated or potentially contaminated areas. They will be asking about the victims. They will be asking if some compensations are being paid to them. They will be asking about rehabilitation. So all of those answers are necessary to develop the national strategies and programs. There are some differences between those documents, but what's important for you to know is that those programmatic documents are going to govern the activities of the government in the field of mine action. Also, the Cabinet of Ministers has to approve the payouts of compensations, providing the shelters for the time of rehabilitation. That these social guarantees are provided by the law on mine action, but unfortunately, DDG, DRC does not have any information about some unified successful practice of providing such social guarantees. As far as we are aware, sometimes victims cannot receive such assistance, partly because they do not know about their rights, but also because there are no clear procedures approved by the Cabinet of Ministers. Also, there needs to be some procedure for the transferring of the cleared land. So I will discuss this in more detail later, but to put it in brief, if there is an operator and the operator has cleaned the area, there needs to be the procedure of handover, where the representatives of local self-governments are also going to take part. So one more thing that is now directly related to what we are discussing, it's about collaboration between the national mine action authorities and the mine action centers. What are the possible forms of such collaboration? First, we saw one of the questions from our participants: what is necessary to do to clear or to mark some area in our territory? Well, you will have to contact mine action centers. You can request the surveying of such an area, and if there is a need to clear this territory, this center will inform about the need to clear it. Also, the National Mine Action Authority and the mine action centers, they can contact you while they are developing the national strategies and plans for the government to have the better understanding about the prioritization of cleaning of the land. Next goes the request for marking of the dangerous areas. In the same way, you can contact the Mine Action Center for them to mark such dangerous areas. We will discuss this in more detail. Also, you can request informing about the risks of explosive objects in schools, for instance, in some governmental or non-governmental institutions, also generally for the general population of your village, town, community. You will have to contact the Mine Action Center, and they have to provide you this information, some materials, or maybe even some people who will explain this to your audience. In the same way, there can be communication with mine action centers in the field of assistance to the victims. I will recommend some things right now, but it's not yet happening in practice. So we do not yet know how it's going to happen, how the mine action centers are going to participate, but still they are going to provide some assistance to such victims. For instance, they can contact the social security institutions, although there is no clear subordination here, but they can provide explanations of their responsibility. Also, they can provide information to the victims themselves about their rights. They can provide explanations of how to obtain certain social guarantees. And it is quite clear that an average person, an average citizen, doesn't know that they can contact mine action centers. So here you can be a bridge between the citizen and their possibility of getting assistance. Also, as local authorities, you will be communicating with mine action centers to inform them about the incidents in your territory. If you had any mine accidents, if you have discovered some dangerous object and you suspect it to be explosive, then you can contact the mine action centers and they will provide you the instructions of how you are going to interact. One more. A section actually is still a continuation with the interaction with the national mine action authorities. As I have mentioned, they can contact you for information which they need for the national plan, program, etc. Also, they can contact you for communication with the operators. They can ask if they actually work in your territory, if you are satisfied by their work. Also, you can send a request to them for clarification of your responsibilities in the field of mine action. And here it's necessary to remember that these are just the first years of those newly established institutions. Maybe this will be their first practice of such kind, but still, the idea is that they have to provide this information to you within their scope of responsibility. So apart from us, DRC-DDG, you can contact them. Also, here you can see participation in the handover procedure. And as I have mentioned, this important procedure embodies the transfer of responsibility for the area which was dangerous or potentially dangerous from operators, for instance, from us, DRC-DDG, to the local authorities and to the government. Having completed all our responsibilities for the clearance of the land, we are going to leave the territory. And we do understand that in the future, the territory can once again be contaminated with potentially explosive objects. So at some point, we have to hand over this land. And at that point, someone needs to inspect the quality of our work so that you, together with the Mine Action Center, can confirm that the operator has performed its work to the necessary extent, and the operator is not responsible anymore for this area in the future. So this is the composition, the governmental institution, the local government, and the operator, and together they do the handover. Also, providing information for the development of programmatic documents on mine action. I have mentioned this a couple of times already. So if the Mine Action Center and the Mine Action Authority needs some additional information, for instance, they want to know if you have suspicions about potentially explosive objects in your area, or you have information about people who need psychological, social, or other kinds of support connected with mine action, you can be contacted by those institutions. One more section here is communication with mine action operators. And as I have mentioned, and as Nick has mentioned, we perform all kinds of operations, starting from non-technical surveys and also informing the population, clearance of certain areas, and also advocacy, etc., etc. So what can be the changes in our communication? The first thing that is not going to exchange. It's the procedure connected with the registration of the project. So it is even more relevant for oblast administrations than the local self-governments. So these procedures are necessary both for the oblast administration and for us to start our activity according to the Ukrainian legislation at a certain area. Next, we mark and also restore the marking if necessary in the territory. I will come back to this once we start the discussion of marking, but overall, you can contact us, you can inform us about potentially dangerous areas or the areas that are dangerous for sure, and the operator can install or renew the marking. Then there are informant sessions, and as you are probably aware, the operators provide such your informant sessions at the entry exit checkpoints, at schools, at the community centers, etc. And some of them are planned, some of them can be requested on an occasion. Also, there are some online products available, and if you are interested in this, please contact us in any way that's suitable to you, and we will provide additional information on EORA. Also, there is some other activity that has to do with demining. If there is an existing project about the clearance of land, there can be communication between the operator and the local self-governments. So we can, for instance, contact you with a request to provide us some useful information, and we will later communicate it to the government and also to our international partners. We will explain about the existing problems. We will explain that we need advocacy because there is mine pollution. Also, you can contact us to learn if there are risks in certain territories, about the things we can do to help you, about the procedures, etc. So the participation in the process of handover, I have mentioned this before. So this is a process that involves the operators, the local self-governments, and also the Mine Action Center. So this is necessary to transfer responsibility that the operator has cleared. Then also providing information for non-technical service. That's something that we have mentioned. One more thing that is very necessary here, and is probably of the highest importance for the support of citizens who suffered from the conflicts and explosive incidents. It's about the assistance to victims. Before 2014, such assistance was provided in a very chaotic way because there was no legal framework for the provision of such assistance. So, for instance, if we had a victim and they suffered an incident, at some point they could get the status of a disabled person. They could get some social security payments, but those payments were not paid not because of the government not fulfilling their obligations. It is not a normal situation that a person living a normal life can lose their extremities, lose the possibility to work, lose some part of their mental health because the government is not fulfilling its obligation. So the responsibility of the government in case of a person getting a disability is quite different in this case, and providing the social support in case of a disability, that's not the correct mechanism. And also providing the monthly payments to the internally displaced persons, it's again not a suitable mechanism. And if the person was born with a disability and getting social security payments, it's again not the same as the government's responsibility for mine accidents. So before 2019, there was no clear framework for rehabilitation, for one-time payments, for annual payments to people who suffered from such incidents. In 2019, there were some changes, some guarantees were provided by the mine action law. Ukrainian people got the right for one-time payment, but this is for children only. Also, there was some limited scope of rehabilitation provided, and I believe that's it. This is very limited scope of social guarantees, and even this limited scope was not really put to practice because the law was not put to practice. In 2020, and once again, this has to do with the question, are we ready? The scope of social guarantees was broadened. And now all the victims, including adults, have the right to one-time payment. They have the right to annual financial support for recreation. Also, they have the guarantees to rehabilitation. Also, they have guarantees for the lodging during such rehabilitation, and if there are no such opportunities in the hospital or the recreation center, they have the right to compensation for the expenses they need to pay for their lodging. That's a good news, and there is a bad news. The bad news is that a number of sub-laws need to be developed by the cabinet, by the Ministry of Health, etc., etc. So for such social benefits to be paid, and for those annual benefits to be paid, lots of things need to be done. And what depends on the local self-governments is first and foremost documenting the incidents with explosive objects. Here, unfortunately, and it's a huge shame that people who become victims of such incidents, they get to hospitals, and even though there are many pieces of metal taken out of their bodies, they still cannot prove that the harm was caused by mine accidents. And quite often, the documentation they get in the hospital is only suitable to get the disability status, or they may get no documentation at all. So in this case, you as local self-governments can contact the medical institutions and inform them that it is necessary to provide the documents which are required for the person to get the status of an explosive incident victim. The form or the template of such a document should be ideally approved by the Ministry of Health together with the Ministry of Social Policy, or simply the cabinet. Currently, it does not exist, but it doesn't mean that the healthcare facilities do not have to provide anything at all. For now, it can be a certificate in any form, maybe some template that is approved within Donetsk Luhansk Oblast, and this will be a legally valid document which will actually help the person to protect their rights. The second part is informing the victims about their rights. Unfortunately, a big number of those victims do not even contact anyone for the compensations, rehabilitation, etc., because they are simply unaware of their rights. And this is purely logical because those people lived their lives, they were not lawyers, they never expected this to become a part of their life. And when something like this happens, the person is under huge stress. This information is not openly available, and even governmental authorities sometimes do not have any unified information for the assistance to such victims. What you can do is to provide this information to, let's see, healthcare facilities, and you can provide the contacts of organizations which have such information. Hopefully, the mine action centers will be providing this information once they are established. Also, you can contact us, mine action operators, who can prepare such certificates for you. Also, you can provide our contacts to the healthcare facilities so that once they get victims of explosive incidents, they can contact us for information about their rights and obligations. Okay, next goes the free provision of medical and other forms of assistance to the victims. So here we speak about social security institutions. Unfortunately, quite often this happens that a person would document the body harm they received. Maybe they have some documents that confirm their rights to this help, but even in such conditions, they cannot get their disability payments, etc. We believe that local self-governments can contact such social institutions in order to contribute to the provision of rights of certain people. And this can be done through a letter, through some kind of a certificate if a person contacts you directly, the victim. This can be communication with social security organizations. Maybe you have some annual meetings with them, and most probably you have a better idea than me when exactly you can contact those organizations, and you can use those opportunities to help the victims. Also, ensuring one-time payments and annual payments to the victims. And this is actually a part of the assistance in communication with social security organizations. We have discussed this already, so I will not go into detail here. Also, ensuring the priority right for education. According to this mine action law, children who became victims of such incidents, they have the priority right to get opportunity to study in institutions of education. We understand that these are not frequent situations. So this implies that a child who suffered from such an accident has some problems with getting education, and this actually may happen. So in this situation, you can contact an educational institution and remind them that such a child has a priority right to get such education, and they have this right at any school, not exactly the school that is 50 kilometers away, but the nearest school, which the family believes is the best for their child. Also, we have mentioned the communication with operator, with the mine action centers, mine action authorities. So you can contact us to request information sessions. We know that currently these information sessions are being provided by government institutions, although the Mine Action Authority has not been created yet, but also there are no limitation for your contacting operators who operate in the territory of your rayon or your town or your village, and we will provide these information sessions. And one more thing that I have mentioned, but we need to discuss in more detail, is the marking. Probably you could even be unaware of this, but in the previous edition of the Mine Action Law, there was some responsibility imposed on the local authorities for the upkeep of the marking of dangerous areas in your territory. So if, for instance, there was a sign and it was broken, stolen, etc., your obligation was to install it. This was against the international standards of mine action because, well, this is not your competence. You do not have the extra information signs, and potentially it is dangerous. So this has to be done by governmental institutions or by operators who can do this as well. So we, mine action operators, together with international organizations, undertook some advocacy work with the parliament and the cabinet, and we ensured that some amendments are made to the mine action law. So right now it is not your responsibility anymore to install or to fix those danger markings. The only thing that you need to do is, when you get information about the destruction of such danger markings, you have to contact the mine action centers or the operator who installed it, and they will restore the protective marking. Please do not do this on your own. This is potentially dangerous and this is not your responsibility anymore. So basically, that's it with my presentation about the opportunities and obligations of the local self-governments, and we can proceed with our Q&A session. I would like to remind you that the questions can be posed not only about my presentation, but also about Nick's presentation. You can discuss such things as what humanitarian mine action is, what are the opportunities delivered by the mine action operators, what are the obligations of the mine action authorities, etc., etc. We have one question from the participant already, and it goes as follows. In the territory of self-government, there is a land used for agricultural purposes, and they would like to clear it. This area is within the 15-kilometer area from the demarcation line. So the question is it possible to clear it? I will give the floor to Nick.
Thank you very much, Oleg. Thank you very much for the question. This is essentially, a very welcoming activity for you to come to mine action operators with questions like this and requests like this. It is a cooperation that we hope will increase in the future years. You definitely always have a lot more information on the ground, and this is very helpful for us as well as we proceed with the identification and then the removal of contamination. Now, the area that you mentioned does require more information before someone can conclusively say if it can be cleared or not. The distance from the contact line is just one factor of the deliberation on whether it can be or how it can be cleared. So what we suggest certainly would be to stay in contact with us, and we will help you send a non-technical survey there to examine the contaminated area, to see how big it is, what kind of vegetation and terrain it has, what are the objects that are around it or on it, if there's any presence of military forces, etc., etc. So there is a lot of different indicators that we take into account before making a decision on the action. But it's certainly very welcome to come to us with such issues, and we will definitely do our best to help you in resolving them. I'm sorry, I cannot give you a conclusive answer right now, but essentially, like I said, it just requires more information before any type of well thought through action is decided on. Thank you.
Дякуємо тобі, Нік. Тобто, якщо
Thank you, Nick. So to sum it up, it depends on a particular situation. You can contact us. We will look into the situation, and I would only add that once the government mine action system will be fully functional, you will also be able to contact the mine action centers so that they can also do this on the part of the government. They would also specify the situation. Maybe they would do the non-technical survey and proceed with the next actions. We tried to be as concrete as possible. Also, Valentina requests contact details. Thank you, Valentina. I will write to your email and provide you the necessary contacts. Do we have any other question that we could discuss here? Thank you, Valentina, by the way, for your question. Actually, we have questions to you, and we are glad that we have this opportunity. So I will give some context in the beginning. As far as we know, there is no single governmental institution right now that would be responsible for the clarification of the mine action legislation. And so the oblast administrations and the local self-governments do not have clear understanding of those provisions. And we even don't know to which extent you are aware of those changes. Are you aware that we got this new legislation? Are you aware of your obligations and rights in the field of mine action? We would like any one of you, dear participants, to answer this question, either the local self-governments or the executive committees or the oblast administrations. Would you kindly share what you have heard from the governmental institutions, from the Ministry of Social Policy, or maybe the Ministry of Defense, internal, any other ministry, about this reform that is underway in Ukraine? If you do not have this information, this is also something that we would like to hear. So please do not be shy, and we would appreciate your input.
Окей. Тоді поділимося інформацією.
Okay, so we will share the information that we have based on our communication with local self-governments and also some of the government administrations. We did not get any information on some clear information policy in this field, of some raising of awareness, and taking into account the complex, the dynamic nature of the legal regulation of this area, we believe that this is a considerable problem, and one of the areas of activity of mine action operators, which we believe to be useful, is development of some information materials that would be provided to the social security institutions, to the healthcare facilities, to the local self-governments, explaining the rights and obligations in the field of social protection of victims, and also other obligations in the field of mine action. We plan to develop this kind of information. We want to make it available online, but also we want to prepare some information bulletins, and also we would like to remind you that we are always open for communication with you. If you request any information material from us, we will be more than ready to provide it. So it only depends on your desire, and this is something that we would like to hear from you, because we, as of now, do not see any systematic work to inform you at the local level. Do we have any other questions from our participants? Or maybe Nick, do you have any questions that you would like to ask the participants?
Nothing from my end, thank you.
Дякую, Нік.
Thank you, Nick. Okay, I believe we can here make some conclusions before we finish. First and foremost, we are grateful for your participation. We understand that it's a new and complex problem that requires special knowledge. We know that we, as a Danish Demining group, we have this chance to communicate with you and help you in solving such problems. Thank you once again, Valentina, about the question you have asked. And as I have mentioned, we will contact you by email with the context you need. As for all the other questions and all the other participants, so once you get any questions about the provisions of the law, the provisions about the social security for the victims, or the clearance of the land, or the communication with the governmental institutions, please contact us, because thanks to the support of the European Union, we are able to inform you on those issues. Thank you so much, and we hope to see you